you to call. And Steve, you're going to explain to us all of the ways that you're going to help and all of the protections currently in place. So thank you so much.
Great, thank you for having me, and we'll definitely focus on the utility and eviction moratorium. So I'm Stephen Dudek. I'm the Education Outreach Coordinator with the Office of Tenant Advocate. And so for the next hour or less, we're going to talk about Renters' Rights 101 during the public health emergency. So what I do want to talk about at the beginning is just what the Office of Tenant Advocate is. We're still operational during the public health emergency. We're well known for our legal advocacy. So if you have a question on what your rights are, how to resolve a dispute with your landlord, can your landlord evict you, can your landlord increase your rent, you can give us a call, and you can call us at 202-719-6560 to speak to an attorney or a case manager. And it's all free. It doesn't matter what your income is. As long as you're a DC resident, you can contact our hotline and get free legal advice. If you have policy ideas on what DC Council should enact to protect tenants or protect the landlords, or any rights that you think should be protected, you can reach out to our policy director, Joe Cohen, and he'll be able to have a conversation with you and see whether that would be fruitful and meaningful action. Education outreach branch, that's what I oversee. So typically before the pandemic, I would go in person to present on various topics on tenant and landlord law, as well as tenant rights. Still doing presentations, but we've now moved them to virtual. So if you are interested in me coming out to speak to your neighbors, to speak to your community, feel free to send me an email, and I'd be more than happy to schedule a time to inform you and present to you on what your rights are. And then the last one is emergency housing. We do provide emergency housing. What that is a 14-day stay in a hotel. You're eligible for emergency housing if DCRA closes your unit down because they view your unit as uninhabitable, or a fire renders your unit uninhabitable. So that only allows you, those are the two eligibility requirements, and usually DCRA or Red Cross will inform you on how to get in touch with the OTA to activate the emergency housing program. So to begin, I just want to go over some of the terminology that you may be hearing. So DC Council, through their legislative process, you may hear that they enacted emergency legislation or temporary legislation. What that really means is the emergency legislation is into effect for 90 days. The temporary legislation is in effect for 225 days. Since this pandemic has begun on March 11th, we are all in the temporary bill. So everything has gone through the emergency 90 days. So all these laws that I'm talking about are in effect for the 225 days. If this pandemic continues to extend into next year and into the spring or summer, hopefully it doesn't get too far, the DC Council will continue to work to make sure these laws stay in place throughout the duration of the public health emergency. So when I talk about the public health emergency, I'm talking about March 11th through what is now at the end of the public health emergency is December 31st, 2020, okay? So when I say at the end of the public health emergency, I'm referring to that date, but that date is not concrete. The mayor has the opportunity to extend it past that date, as well as the DC Council. So the DC Council may give Mayor Bowser the authority to extend the public health emergency into 2021. My personal opinion, due to the state of the country and the DMV area with the pandemic, we're looking to probably have that pandemic or have the public health emergency be extended into 2021. So the way I crafted this presentation was just to give you a foundation of what your rights are, but really go into how that law has changed because of the public health emergency. So the biggest thing to know is when you sign a lease in DC, you cannot be evicted just because your lease expires. Your tenancy automatically has a right to continue as a month-to-month tenancy. So here in DC, if you pay your rent on time, if you abide by the terms of your contract, you can live in your unit for the rest of your life. And I would say that is probably one of the most fundamental rights a tenant has here in the district, because other jurisdictions have a tenancy at will, where landlords can just evict the tenant just because they want to. But that is the biggest takeaway I want you to get from this slide, is that you cannot be evicted just because your lease expires. You have a right to continue as a month-to-month tenant. The other thing to know is if you sign a lease, the landlord cannot unilaterally change the terms of the contract. Your lease is a contract that you agree to. And so if you want to change anything in that lease, or if your landlord wants to change anything in that lease, you both have to agree to that change, okay? And that's important because the public health emergency may dictate a certain lease clause that you want to change. And you can't change it unilaterally. The landlord can't change it unilaterally. So you must come to agreement and most likely sign an addendum to the lease to clarify what that change is. So I just want you to be aware of that, have that foundation. So impact on leases. How has COVID-19 impact on leases? The first thing is late fees. During the public health emergency, the landlord cannot charge a late fee. So starting March 11th, there is some debate, but I would say the landlord could charge a late fee for the month of March, because if your rent was due on the 1st, a late fee can be charged on the 6th of the month. And that was before the public health emergency was enacted. But after that, April, May, June, July, August, September, October, November, December, the landlord should not be charging you a late fee if you do not pay your full amount of rent on a monthly basis. What I would recommend is going down to your rental office, asking your leasing official for a copy of the ledger to ensure that if you have not paid your rent on time, that you will not be charged a late fee, okay? If you are charged a late fee, please contact the OTA. We can assist you in that matter to make sure those charges are removed. And that's something that you need to know. And this is extended through the end of the public health emergency. So if the public health emergency gets extended into 2021, this right will be extended with the public health emergency. Forms of payment of rent. This is something you would always want to go over your lease to see how you pay your rent. At the beginning of the public health emergency, we got a lot of calls of tenants who feared going out to the post office, the bank, Walmart, just to get a money order. And what we told those tenants is that you need to have a conversation with your landlord. You need to talk to them and say, hey, this I feel uncomfortable with. Are there alternatives to paying my rent? And if the landlord agrees to it, this is where you would put something in writing. And this is what I talked about the previous slide, where you would need to sign an addendum to your lease. And if you change the way you pay your rent, you want to have that in writing. If you don't have it in the lease or a signed addendum, at least a text message or an email to show that you both agree to it is essential. And you also want to make sure how long this process or the way to pay rent is available. Is it just available during the public health emergency, or is it available for the rest of your tenancy, for the duration of the tenancy? And you want to communicate that with your landlord. And I would say the underlying themes of this presentation is to have effective communication with your landlord and to have the appropriate documentation. If you do that, that will hopefully take some of the stress away and allow you to have fruitful conversations with your landlord and hopefully fruitful action throughout this tough time. Amenity fee refund. So unfortunately, this only applies to rent control properties. So if you aren't a rent control property, this would not apply to you. And we will cover how to distinguish whether you're a rent control property or not a little bit in the presentation. But the biggest thing to know here is that if you're a rent control property and you pay an amenity fee on top of what your rent is, so the amenity fee is separate from what your rent is, then the landlord must return that value of the amenity fee back to you. If your amenity fee is built into your rent and is part of your rent, the landlord does not have to deduct that cost to you. And it's important to know the difference. The reason being is if it's part of your rent, the legislative intent is that the landlord is trying to comply with the shutdown orders offered by the mayor, and they're not doing it on their own volition. And so therefore, the law felt that they can't penalize them for not providing you the amenity service. So if you live in a rent control property and you pay an amenity fee on top of your rent, and the landlord took that away to be in compliance with the mayor's order with emergency legislation, you should be refunded. If it's part of your rent, unfortunately, you will not be entitled to a refund. So I just want you to be clear on that distinction. Utilities. Utilities have been impacted because of COVID-19. No utility company, electric, gas, or water, should disconnect your service during the public health emergency plus 15 days thereafter. So if the public health emergency ended and you haven't paid your utility bills, they can't on January 1 shut your utilities off. They would have to wait until the middle of January to do so. If you need assistance paying your utility bill, please seek other government agencies. There's the Department of Energy and Environment that has available resources such as the LIHEAP program. I believe the LIHEAP program deals with heat, and we're heading towards the winter, so that's something you definitely want to check out. Also, the Office of People's Counsel. They're your consumer advocates for utilities, and I would recommend reaching out to them. They do great work and great advocacy for you, and they may have available resources. Now, cable and telecommunication companies is a little bit different. If you're unable to pay your cable or internet bill, what they can do is bring you down to the basic level. But what they can't do is completely disconnect that service, because some of us still may be at work. We're all doing virtual learning for school, which can be very frustrating, but you should still have that service so we can fulfill those needs and those requirements. If you are struggling to pay your utility because of COVID-19, and COVID-19 has significantly impacted your finances, you are eligible for a utility payment plan. Because unfortunately, COVID-19 does not just take away that responsibility to pay your bills, both for utilities as well as rent, which we'll cover in a little bit. So you still have to pay for the services that you rendered. So if COVID-19 has affected your finances, you're eligible for this program. And this program period is the public health emergency plus 6 months, okay? And the 6 months is more for the utility companies such as electricity, gas, and water. If it's telecommunications such as cable and internet, those are 60 days after the public health emergency ends. So you have a good chunk of time to be able to call the utility provider, say, hey, unfortunately, I'm still rendering your services. I can't pay for those services, but I would like to make a payment plan. All you have to show that you've been affected or your income has been affected by the COVID-19, and you should enter into a payment plan. I would always recommend is if you agree to a payment plan, make sure you can honor it 100%. Okay, and that's why we built in some time for tenants to agree into it. Because remember, when the public health emergency ends, you still have 6 months to reach a payment plan with your utility provider. And so I would say hopefully by that time, the economy will be back up to where it was before the pandemic, and we all can have a better indication on what we can pay and what we can't pay. But the biggest thing is to be proactive. Do not wait, okay? Call your utility provider, talk to your landlords. hey, I'm having these financial issues. It's not the easiest thing to discuss, but you don't want to wait. You want to have the conversation early because they may be able to finagle some things to assist you or lessen the burden. Because as this pandemic continues to go on and on, unfortunately, these bills are going to continue to pile up, and the burden on you is going to be felt immensely, especially when the public health emergency ends. The other thing to know is that if by chance the utility providers disconnected your service during the public health emergency, which again they shouldn't be doing, but if they do, they should come out immediately to restore your utilities, and they should not charge you a fee to reconnect during the public health emergency. So I just want you to be aware of that. But again, I can't stress this enough. Be proactive. Have those difficult conversations now. Do not wait until the end of the public health emergency. So rent control. What I do want to let everyone know is that every building or every residential building in DC is subject to rent control. However, you have your exclusions and your exemptions. Your exclusions are your dormitories, nursing homes, foreign government owning the property for their diplomats, public housing. They're all excluded from the rent control laws because they have their own way on determining what that rent is or if they're charging rent. And then you have your exclusions. There's 7 exclusions, but there's 2 that we really need to focus on. One, any building built after 1975 is automatically exempt from rent control. So all this new development that's happening in the district is not subject to the rent control laws. Maybe affordable housing, but again, is not subject to the rent control laws. The other thing is the small landlord exemption. What that is a individual, not a company, so it can't be Stephen Dudek LLC. It has to be Stephen Dudek, the person, who owns 4 units or less in DC can claim the small landlord exemption, meaning that they don't have to adhere to the rent control laws. And now it's not building, it's 4 units. So if I have 2 buildings with 3 units each, I can't claim the small landlord exemption. So it's very important to make that distinction. So what does rent control do? Rent control limits how high a landlord can increase your rent, okay? So if you live in a rent control property, your landlord can increase your rent once every 12 months based on the consumer price index plus the 2% general applicability. The consumer price index is determined by the government every end of March, early April, and goes into effect May 1st to April 30th of each year. Okay, this year the CPI is 1.1%, then there's a 2% general applicability. Okay, and so if you live in a rent control property, your rent cannot be increased or can be increased by 3.1%. But they do have to issue a 30-day notice of a rent increase. If you live in a non-rent control property, the landlord still has to issue a 30-day notice of a rent increase, but they're not subject to rent control laws. So the rent increase can be as high as the landlord wants, and the landlord can increase the rent as often as they want, as long as you're a month-to-month tenancy and as long as they provide the 30-day notice. Now, this applied to all the tenants before the pandemic. What happened because of COVID-19 is all rent increases are prohibited. There should not be, your rent should not be increased from March 11th to now through December 31st, 2020. If, say, for example, you received a notice of a rent increase at the beginning of March, that should be voided, okay? I can't stress this enough, your landlord should not be increasing your rent. If you're moving to a new unit, you want to double check what the rent is beforehand, because I think you can make a colorful argument that your rent should not be increased as well. That I can't stress enough. The other thing is, unfortunately, the landlord is still able to collect rent during the public health emergency. You do have to pay your rent. If you're unable to pay your rent, you need to talk to your landlord, okay? if COVID-19 has significantly impacted your finances, the landlord does have to enter a rent payment plan for you, okay? The landlord must develop it, and you're eligible to make a rent payment plan during the public health emergency plus a year after, okay? And the payment plan covers the rent during the public health emergency and that additional year. The minimum term of the length of the payment plan is a year, okay? It should be no shorter than a year unless the tenant himself consents to it or agrees to it. And it should be deferred payment of rent installments over that time of the rent payment plan. Now, the difficulty or what we've seen tenants are experiencing is that the law shows that the landlord is responsible to demonstrate how you show you were financially burdened by COVID-19. And also they are the ones who control the application procedure and what supporting documents that they are requiring, okay? And so if you are having difficulty with getting a rent payment plan from your landlord and you've been financially burdened because of COVID-19, please again contact the OTA so we can discuss what options are available to you. One of the options would be filing a tenant petition with the rent administrator stating that the landlord either wrongfully denied your application to a rent payment plan or failed to provide you a rent payment plan, okay? Because they are required by law to do so as long as you can provide to them that you've been financially burdened due to COVID-19. They should also give you opportunities to apply on phone and online. If you have any questions about this, please contact us because we do have some calls where landlords are trying to be very intrusive into a tenant's financial records. For example, one landlord told a tenant that they could not enter a rent payment plan until their savings account was $0. That is horrendous and that should not happen, okay? All you need to do again is prove that COVID-19 affected your financial income. So that could be a letter from your employment saying that they have to let you go due to the economy, due to COVID-19. Could be some bank statements to show if you're self-employed or an independent contractor to show before the pandemic that money was coming in and now it isn't. These documents should not be intrusive. So I just want you to be aware of that. But these rent payment plans is a way for you to preserve your tenancy and not be at a risk of eviction. Because when you agree to this rent payment plan, the landlord cannot move to evict you as long as you satisfy the terms of the payment plan, okay? I want to reiterate that again, if you satisfy or if you're in compliance with the terms of your payment plan, the landlord cannot move to evict you when the public health emergency ends. And we're definitely going to talk about evictions before the night ends. The other thing that I do want to mention is some tenants feel uneasy agreeing to a rent payment plan because they don't know when their money is going to come in, what their source of income will be. And we always inform tenants not to sign an agreement until they're 100% sure that they can satisfy the terms of the agreement. And so unfortunately, it may be tough, but I would have that conversation with the landlord. I would be clear with them as I really can't agree to any terms of the rent payment plan because I don't know if I can satisfy those terms. And I would update them, maybe not on a monthly basis, but on a quarterly basis until you know, okay, I can pay. If you can pay any little, try to chip away at the debt that you're accruing with your landlord because you don't want it to be burdensome when the public health emergency ends that you can't fulfill the terms of the rent payment plan. And there are available rental assistance programs to you. Last week, I held a rental assistance program presentation with DHCD, Director of Policy, Polly Donaldson from DHCD, community-based organizations that manage all the rental assistance programs. So if you go on the Office of Tenant Advocates YouTube page, Please check it out. It's an hour and a half long, but it really gives you necessary detail about each program and the available funds to you. So I do want to cover two main programs that you should definitely look into. The first one is called the CHAP program, the COVID-19 Housing Assistance Program. They just upped the numbers, but this covers up to 6 months of owed rent or $8,500, whichever is lower. So this is money that you've owed. They can't apply this to the future. How you are eligible, you must demonstrate the rent payment plan, that you need you need the money, you've been affected by COVID-19, but also that you can't earn anywhere higher than 80% of the median family income. So that's based on a family of 4. And if I remember correctly, I want to say that's probably around 80,000, between the 80,000 to 90,000 range for income. But the CHAP program, all the community-based organizations will have a better sense if you qualify for that. But please check that out. It may be best to get this money now to chip away at your debt. The other program is the tenant-based rental assistance program. It's called TBRA for short. This covers at least 6 months of rental assistance. And this can be applied to back rent or even future rent. So this can be very useful, but there are strict eligibility requirements. You must live in a building with 50 units or less. Again, similar to the CHAP program, you have to show that you're delinquent on your rent payments, you've been affected by COVID-19, and this is 60% of the median family income. Through the presentation that we did last week, this program is only available through December 31st of 2020. So if you're eligible for the TBRA program, I would definitely recommend applying. I did put the link at the bottom of the slide that talks about these programs in detail and how to apply. Please do not wait. Try to go through the application process because it does take a couple of weeks to actually get the funds to the landlord. There is a program that isn't on the slide but is still available to tenants, and that's the Emergency Rental Assistance Program. It's ERAP is the acronym. That is for 125% federal poverty. So that is a very low income individuals can utilize it. I know there is a bill in front of DC Council to change the eligibility requirements. So that is something you may want to just keep an eye on because you may be eligible after the law changes. But they provide up to 3 months of back rent or $4,250, whatever's lower, they'll provide. You can talk to the same organizations such as CHAP who oversee it. They oversee ERAP as well, and they can make a determination on what programs you qualify. But I can't stress this enough. Try to apply for these programs now. Try to lower the amount that you owe because no one knows when this pandemic is going to end. No one knows when this public health emergency is going to end. So utilize these rental assistance programs. Please, please, please. Housing code. So yes, the landlord, even amongst a public health emergency, must provide a safe, clean, habitable unit. And that is also known as the implied warranty of habitability. So both your unit inside and your common spaces must be safe and habitable. If you have issues, there's 5 things you need to do. The first thing is document. Document, document, document. Use technology at your hands. Take pictures, take videos. Try to communicate the issues with your landlord. You do need to notify your landlord first because he or she does have to have the opportunity to fix it, okay? If he doesn't fix it, after you document it and notify the landlord, you have 3 available options to you. One is to contact the Department of Consumer and Regulatory Affairs to have them do an inspection of your unit. What are they going to inspect? They're going to inspect whether your unit is in violation of the housing code. Right now, they are doing virtual inspections, so hopefully you have the capacity to get to FaceTime or WebEx or Zoom. They'll schedule an appointment and have you go through your unit with your technology. If they deem that your housing code issues are severe enough, then they will send a inspector to do it in person. Okay, and I would definitely recommend to contact them. They will file a report. They will talk to the landlord to make sure that they are aware of the housing code violations in your unit. If you don't want to contact DCRA, or if you did and nothing has changed, you can file a complaint in Housing Conditions Calendar. Housing Conditions Calendar is a branch of the DC Superior Court that focuses on whether your unit is in compliance with the housing code or not. You can file your complaints online. DC Superior Court is starting to protect or is trying to host virtual hearings. If you do not have the technological ability to attend those remote hearings or virtual hearings, they do have different remote workshops or labs to be able to have you attend and access the hearing. Housing Conditions Calendar is really straightforward. It's fact-based or fact-oriented, and you're there to show the court that there's housing code issues in the unit and that they need to order the landlord to fix them. And this is why documentation is key. Documentation is key at the beginning to document the problem and notify the landlord, but it's to show and prove your case. The fifth thing is the payment of rent, right? You are paying rent to live in a safe, clean, habitable unit. The Office of Tenant Advocate does not advise tenants to withhold their rent for two reasons. One, if you withhold your rent, you run the risk of being evicted. You may be right. You may be able to win the case, but most often or not, tenants do not withhold their rent correctly, or they do not assess the damage correctly. And so when they should have only paid half their rent, they didn't pay any rent, and now they're in a slippery slope and in an eviction proceeding. The second reason why we don't advise tenants to withhold their rent is because even if they win their landlord-tenant case, they can lose the war. They can have a negative rental housing history. And so if you withhold your rent, your landlord took you to landlord-tenant court, and then you won your court case, but you went to move out to find a new place, all those new units, when you fill out the application, they'll do a rental check into your rental history, and they're going to see not that you won your case. They're going to see that the landlord took you to court for non-payment of rent, and most likely will have your application be denied. So that's why we at the Office of Tenant Advocate do not advise tenants to withhold their rent, but there are other legal agencies who will advise tenants to withhold their rent. So I just want you to know. If you don't want to withhold your rent, but you feel you're entitled to a rent abatement, you can write a demand letter to your landlord saying, hey, I lived with these housing code issues for this length of time, and I believe I should be compensated, and this is how much I believe I should be compensated for. If they don't adhere to that demand letter, then you have every right to file a complaint in small claims court, which is like Judge Judy without the TV cameras, where you can hopefully make the winning argument to be compensated for the conditions that you were living in. How has COVID-19 impacted the housing code? It's made a significant change that the landlord must clean the common areas on a regular basis, including surfaces such as doors, railings, seating, and exterior mailboxes. Regular is not defined, so this could be once a day, once every other day, a couple of times a week, but the landlord should at least be cleaning these high traffic areas, these common areas. If you don't think your landlord is doing it, you can contact the Office of Attorney General, and you can also contact DCRA. They would be the appropriate authorities to contact. Quiet enjoyment. So just to let you know, when you're renting your unit, you have exclusive possession of your unit. You have the right to say who enters or who doesn't enter. The only one that can enter is the landlord, right? Because he still owns the building. He still technically owns your unit. But he can't enter anytime that he wants. For non-emergency reasons, such as doing repairs, inspections, showing prospective tenants the unit, or showing the unit for government repairs, they have to issue a 48-hour written notice. So email, text message, posting on the door, a pigeon carrier delivering the letter, they have to give you that 48-hour notice, and they can only enter Monday through Saturday from 9 a.m. to 5 p.m. This is not for federal holidays. Sundays they can't enter or should not enter. It's only Monday through Saturday from 9 a.m. to 5 p.m. after they give you the 48-hour written notice, okay? And this is only for non-emergency reasons. If there's an emergency, they have every right to enter. If they continue to say everything is an emergency, document that, contact the OTA, because we'll probably need to have a discussion with that landlord. Now, this applies before the pandemic and during the pandemic. So the landlord, unfortunately, can still enter your unit during the public health emergency. If you feel uncomfortable, if you feel that you don't want the landlord to address anything in your unit during the public health emergency, have those conversations with the landlord. I personally had to have that conversation with the landlord. One of the pipes leading to the sink burst. It caused water damage in the kitchen floor or in the kitchen ceiling. Contacted the landlord, he addressed it, but we had a conversation saying, do you know what, we don't want too many people in the home. We're okay living with a hole in the ceiling for a little bit. Can we have someone come out when the numbers go down? And he worked with us, and we contacted him in August, say, hey, we feel comfortable. He sent someone out. Everyone was happy because we were able to address the emergency, so there wasn't too much damage to his property. And we felt comfortable that, okay, the numbers are a little bit low. We had a conversation with the agent coming in, the maintenance worker, on how he was adhering to social distancing, the mask requirement. It's important to have these conversations and to voice your concern. The landlord, unfortunately, does have every right to say, no, I understand your concern, but I'm still coming in. I'm doing everything legally, and we need to address it. If you have concerns, please contact the OTA. But again, all landlords, agents, maintenance workers, visitors should be honoring the social distance, should be wearing a mask, cough, sneeze into your elbow, don't have physical contact. If a landlord comes into your unit, clean after, wipe every surface down that he touches it. Try to protect yourself, because we don't know when this pandemic will end, but we do know how dangerous this pandemic is. And so take all necessary precautions to not only protect you and your family, but also to protect the landlord and the agents of the landlord as well. So the last big topic of the day is the evictions. So I'm going to cover what the law was before the public health emergency, and then we'll get into a conversation on how COVID-19 has impacted the eviction statute. So what you see here on the screen right now is the only 10 reasons a landlord can evict a tenant in the District of Columbia. If the landlord gives you a reason that is not on the screen, it's an illegal eviction, okay? Remember, you cannot be evicted just because your lease expires. You cannot be evicted because your property is for sale, okay? Those are probably the two common myths that we get from tenants. I want to be outright and say you cannot be evicted for those reasons. I do want to cover some of the eviction, the statutory reasons. The first one is non-payment of rent. I would say 90 to 95% of the evictions is because of non-payment of rent. Couple of things to know. You can waive your right to a 30-day notice to vacate for non-payment of rent cases only. You waive that right as long as the lease that you signed waives that right. It's usually in the middle of the lease, clause 20 to 24. It's right it's bolded, it's black. It states that you waive your right to a 30-day notice to vacate for non-payment of rent cases only. That is completely legal. The landlord, if you do not pay your rent on time, has the right the next day to go down to landlord-tenant court to file an eviction complaint against you. Okay, so I just want you to be aware of that. However, there is a protection for the tenants to preserve your tenancy. So even if you lose your court case for non-payment of rent and the judge awards possession back to the landlord, you can still preserve your tenancy, and it's called paying the trans-lex amount. The trans-lex amount is the money that you owe, court fees and court costs, and your current rent. If you basically render your balance zero before the U.S. Marshals come to execute the rent, the landlord has to accept that money and you preserve your tenancy. If you're even a penny short and you can't have that balance be wiped out, the landlord does not have to accept that money. The biggest thing is always calculating your current rent. Because it may take a while before the U.S. Marshals execute the writ. So you want to make sure that you get that balance to $0 and preserve your tenancy. The second common type of eviction is breach of lease. If you breach a term of your lease, the landlord must issue a 30-day notice to correct or cure. In that 30-day notice to correct or cure, they must identify your actions, how your actions violate the lease, which lease clause you violated, and how you can cure that violation. It's essential that they state how you can cure that violation, and it has to be a realistic cure. For example, if you have an unauthorized occupant, that unauthorized occupant needs to be out of your unit. If you're doing some action such as smoking in your unit, you may want to stop smoking, because if you cure that violation within 30 days, the landlord cannot proceed to file a complaint in landlord-tenant court. If you do not cure that violation within 30 days, the next step would be for that landlord to file an eviction complaint in landlord-tenant court. Some other things to know about for breach of contract is landlords can only go back 6 months. They can't hold something over your head a year ago, 2 years ago, 3 years ago. They can only go back 6 months. And that's something important to know. But the biggest thing, again, is that the 30-day notice to correct or cure should stipulate how you can cure that violation and prevent your landlord from filing an eviction complaint. The others, I'm just going to run down real quick. Number 3, illegal act within the rental unit has to be adjudicated, warrants a 30-day notice to vacate. 4 and 5 are similar, but there's a unique difference between them. If a landlord wants to move in for their personal use and occupancy of the unit, so this usually applies only to single-family homes, rented condos, they must provide a 90-day notice to vacate. That applies to the landlord's spouse, the landlord's children, the landlord's parents, the landlord's siblings, is all in that web. Typically, we see this if the landlord is moving back to the district to work, or their son or daughter is going to school in the district, they will issue a 90-day notice to vacate to the tenant. Number 5, same thing, 90-day notice to 90-day notice to vacate to the tenant. But this is where that single-family unit or home is up for sale, and the buyer wants to move in for their personal use and occupancy. They're not being evicted just because they're selling the building. They're being evicted because the buyer wants to move in for their personal use and occupancy. Again, that warrants a 90-day notice to vacate. If you receive a notice to vacate for any of the reason, you do not have to vacate at that time, okay? If you stay past the notice to vacate or the notice to vacate expires, the next step is for the landlord to take you to court. You do not have to leave. If you don't want to be taken to court, then it's best to leave when that notice to vacate, before that notice to vacate expires. 6 and 8 deal with temporary evictions. This is where the landlord wants to renovate the unit, but can't do it safely unless you move out of the unit. This is a temporary eviction that warrants a 120-day notice. And it's a temporary eviction because after the renovations are done, you have a right to return to that unit. And so that's the biggest thing. Landlords should provide relocation assistance. They may have a plan for you, but the biggest thing is when the renovations are completed, you have the right to move back into the unit. 7, 9, and 10, demolition, discontinuance, condo conversion, they all warrant 120-day notice to 180-day notice to vacate. Again, the biggest thing is you cannot be evicted just because your lease expires. But again, the landlord must go through the judicial process. The landlord can't change the locks. The landlord can't throw your stuff on the street. If you're not abiding by the terms of your lease, if you're not paying for your rent, they must go through the judicial process. There is no self-help eviction allowed in DC, and especially that's important to know now because we are hearing that landlords are resorting to illegal actions and trying to force tenants out. So if you are in that situation, please contact us. Please call the police. They are trained in a situation. Sometimes it doesn't work all the time. But if you have questions or if you've been threatened for an illegal eviction, please contact the OTA. Also know that if you have a writ, the U.S. Marshals are the ones that execute the writ. The landlord should not be there by themselves saying that they have a writ and trying to get you out. The U.S. Marshals are the only ones who can execute the writ. A myth, some tenants believe that evictions do not occur on rainy days or in the winter. In the winter, evictions do occur unless there's a forecast of the temperature to be 32 degrees or below by 8 o'clock in the morning. If it's raining in your neighborhood, the landlords and the U.S. Marshals will postpone the evictions for that neighborhood. So if it's, say, thunder and lightning in the southeast and it's nice and sunny in northwest, all the evictions will occur in the northwest but be postponed in the southeast. Back in August of 2018, the eviction process has changed. Before, DC was one of 3 jurisdictions in the country that still allow the eviction process to throw the tenant stuff on the street. And we would hear just very sad stories of tenants not being notified that they were being evicted and would come home to see their stuff on the street in their neighborhood having a free-for-all of all their personal items. So this law is progress and changes a lot of things. So no longer will a tenant's property be put on the street. The other thing is the housing provider must notify the tenant within 21 days before the eviction date that, hey, you got 3 weeks before you're going to be evicted, you want to plan accordingly. On the day of the eviction, the U.S. Marshals will be there, the landlord will be there, the U.S. Marshals will do a sweep of the building, make sure every human being is out of the unit, and then observe the landlord changing the locks. You're like, great, my stuff isn't on the street, but now it's behind a locked door. What happens now? You have 7 days from when your locks have been changed, excluding Sunday and federal holidays, to get your stuff out. If you do not get your stuff out within those 7 days, your stuff is considered abandoned. Therefore, the landlord could throw it away, could keep it for himself, could sell it. He can do whatever he wants because you lose all ownership to your possessions. Now, during that 7-day period, the landlord must give you a opportunity to get your stuff, and it's 16 hours over 2 days, so 8 hours each. You can request that to be on the weekend. The landlord should work with you. If the landlord is not working with you, you have every right to file what is known as a preliminary injunction against the landlord in the landlord-tenant court. What a preliminary, injunction is basically a way for the tenant to tattletale on the landlord for not abiding by the law and have the judge scold the landlord for not abiding by the law. If you come into these types of situations, contact the OTA so we can advise you on how best to proceed. So that is how evictions were happening before the pandemic and the mayor issuing the public health emergency. What has happened now is that the DC Council enacted an eviction moratorium. And I would say this is probably one of the strongest eviction moratoriums throughout the country. And the landlord cannot evict you during the public health emergency plus 60 days thereafter. Okay, let me repeat that again. The landlord cannot evict you during the public health emergency and 60 days thereafter. So if the public health emergency ended on December 31st, 2020, the landlord still cannot evict you until the first week of March, because remember, February only has 28 days and screws everyone up. Okay, so just be aware of that. My office, the OTA, the Chief Tenant Advocate, Johanna Shreve, in her testimony in September, lobbied DC Council to consider changing that 60 days thereafter to 120 days thereafter. I know other tenant advocates have done so as well, because we want to make sure that when this public health emergency ends, that tenants have the time to find a job, have a time to find a source of income to preserve their tenancy and prevent an eviction. There's other things that the landlords can't do. They can't file an eviction complaint during the public health emergency and 60 days thereafter. They can't serve an eviction summons. If they want to, or when the public health emergency ends, they'll have to, and you had an eviction notice or writ of eviction against you before the public health emergency, they would have to give you a 21-day notice before they can execute that writ. And what just passed 2 weeks ago and was signed into the law last week is that the landlords cannot issue a notice to vacate to tenants during the emergency and 60 days thereafter. That has gone into effect starting October 14th. Unlike the other laws, it's not retroactive to the beginning of the public health emergency. That is only in place from October 14th throughout the emergency and 60 days thereafter. So if you received a notice to vacate today from your landlord, please contact our office. Please know that they should not be issuing that, because a lot of tenants were confused, a lot of tenants were angry, and a lot of tenants unfortunately vacated their unit in the middle of a pandemic because they received these notice to vacates. So it's essential just to be informed on what your rights are, be knowledgeable about your rights, and if you have any questions or concerns, reach out to your ANCs, reach out to your council members, reach out to the OTA, make sure you know what your rights are and how to react accordingly. TOPA, again, TOPA is a Tenant Opportunity to Purchase Act. If your building is being sold, depending on the size of your building, you do have TOPA rights. The biggest thing to know is that all TOPA deadlines are paused during the public health emergency plus 30 days thereafter, which gives tenants a lot of leverage, right? Because the owners want to sell this building, but they can't close on the sale of the building unless the tenants activate their TOPA rights and have gone through the TOPA process. So that is the biggest thing to know. You don't have to rush to an agreement with the landlord. You can say, you know what, I'm going to wait until the public health emergency ends, and then I will adhere to the TOPA process and all deadlines. It is essential to communicate that to the landlord so the landlord knows that you're informed on your rights. And the same thing applies to all other rights. Say taking your landlord to court for a breach of contract or a return of security deposit. All those rights are stayed throughout the public health emergency plus an additional 30 days. So there would not be a statute of limitations argument in your types of cases. And then the last topic that I want to cover is vacating your unit. The biggest thing to know is if you're a month-to-month tenant in DC, it's best to give a 30-day notice at the beginning of the rental period so it expires at the end of the rental period, so meaning a month. Because if you give your landlord a 30-day notice in the middle of the month and expires in the middle of the month of the next month, the landlord does not have to prorate your rent. He has every right to charge you the rent for that full month. So for example, today is October 22nd. I give my landlord a notice today that expires November 21st. I'd definitely be charged for the 21st, November 1st through the 21st. And if the landlord wants to stick it to me, he can charge me for the remaining 9 days of November. So I just want you to be aware of that. Your lease can require a notice longer than 30 days. If it does, it has to have a specific provision saying you're entitled to a notice of a rent increase 15 days before that deadline. For example, if the lease requires you a 60-day notice of you terminating the tenancy when the lease expires, you have to be given a notice of a rent increase 15 days before that notice, so 75 days before your lease expires, so you can make that determination on whether you want to stay in the unit or not. How COVID-19 has impacted vacating the unit. If you decide to vacate the unit and you don't feel safe vacating the unit during the public health emergency, you can inform your landlord that you do not want to vacate and that you'll vacate when the public health emergency ends. This is a protected right, but this is a right that the tenant has to enforce. The landlord is not going to come and say, hey, do you want to do this or not? If you do stay in the unit when that public health emergency ends, the clock starts ticking. So for example, if I gave a notice to vacate to my landlord on March 1st, and then after the mayor declared a public health emergency, I say, you know what, I want to hold off. When the public health emergency ends, I would have 20 days to vacate the unit. But again, I have to go and talk to the landlord, put that in writing, make sure the landlord is aware of that, and I won't be deemed a holdover tenant. I won't be penalized for making that election. So I just want you to be aware that tenants vacating the unit do have that option as well. But that concludes my presentation. I hope it was fruitful. I hope you learned a couple of things. If you have any questions or concerns, you can definitely reach out to the OTA. You can ask for Steve Dudek. I believe I may have my information. So again, this is a hotline number. If you're interested in wanting to be updated on any OTA events or legislative updates, you can email me your email and I can put you on the OTA mailing list. We don't bombard your email. I'd say on a busy month, we probably have 4 to 5 emails. On a typical month, maybe 1 to 2, but mainly the emails are to inform you of OTA events or legislative updates. So if you have any, if you want to join that, please just send me an email and I can add you to that list. And again, here's my email at the end. Here's my phone number. Feel free to contact me if you have any questions or concerns. We're here to help. We're here to make sure that you're informed, especially in this very stressful time. So please do not hesitate to ask a question. There's no stupid questions. We just want to make sure that you're informed and you know how to act accordingly to the landlord's actions. So again, thank you for this opportunity to present, and have a good night.
I want to sort of open it up. I know that we have a smaller audience at this time, and we also have a meeting starting in about 10 minutes. But I want to thank you. This was incredibly comprehensive. So it really didn't leave a lot of unanswered questions. I know one of the things I have heard that wasn't addressed is one, the issue of non-written leases. And that can be something that maybe we follow up if that's maybe a bigger answer than what we have time for. I also have a question about late fees, and what I understand they can't be charged, but can they be held over and accrued?
So I'll do the late fee and then go back to the oral lease. So the late fees can't be charged at all. And before the public health emergency, the 4 things to know about late fees is: 1, you can't be evicted for non-payment of your late fees. 2, there's a grace period of when your late fee can be charged. And that grace period is 5 days. So if your rent is due on the 1st, you cannot be charged a late fee until, the 6th of the month. The third thing is the late fee is capped at 5% of your rent, and this all has to be written in your lease. If you don't have a lease or there's no late fee provision in your lease, you cannot be charged a late fee. And the last thing is that you can only be charged one late fee a month. So again, during a public health emergency, there should be no charging of a late fee, but say you get back into normalcy, I guess is the best way to phrase it, and you miss a payment of your rent, or you stop paying your rent on time, you should only be charged a late fee for that month. What they can't do is say, okay, you paid November's rent, but you owe September and October, so we're going to apply November's rent for September and charge you a late fee for November. They can't do that, and that's why the law has changed. So you should only be charged a late fee for the month where you did not make your full monthly payment. And then in regards to the tenants who don't have a lease, who just have an oral contract, the biggest thing for them is to prove that they have an oral contract. So satisfying the elements of contract, which is offer, acceptance, and consideration. Offer and acceptance is self-explanatory. Consideration is defined as each side suffering a legal detriment. Classic example is the payment of rent. The tenant's legal detriment is they're using their income to be able to pay for their rent and have exclusive possession of the unit. The landlord's detriment is that they no longer have full ownership of the property, that they give you the exclusive possession of that unit. So if you have something in writing in some way to document that you can satisfy that consideration element of a contract, you're a tenant and you have all the afforded protections of the law as a tenant who has a written lease. So nothing changes if you are a oral tenant.
Okay. And Beatrice, because I know I have heard this from members of our immigrant communities that have sort of non-traditional written leases, that this has been an issue and that they have been pushed out of their units based on it. Beatrice, is this something that you've heard in with those that you guys are working with?
It is a concern of a lot of our family members, also due to they're unemployed and they're not able to get their hands on a lot of resources. So I do know that what you all have provided will be beneficial to them. It's just a matter of making sure that we're able to distribute all of it in the right amount of time and that they're able to be accepted into these programs.
Okay. And we can, I guess as we're listening to this, Beatrice, if there are things in particular from this information that we want to flag, highlight, pull out, and either break down further or make it more, I guess, just clearer and easy for our communities, maybe that's something we could work with you on, Steve.
Yeah, most definitely. And as I sent you all those handouts, both in English and Spanish, that will be definitely a way to go as well. And I'm always trying to look to simplify the message, just because some attorneys, even on the OTA staff, can be very long-winded. And at the end, you're just like, I get it, but I really need to have something to review just to really have that message hit at home. And same thing, I can be very long-winded sometimes too. So
no, it was incredibly helpful. And like I said, there's just, I have a lot to chew on. In fact, I have some more questions I can follow up with you. And I guess if anybody else who is listening or does listen to this after tonight, you know, as Stephen has given his contact information, I know that my interactions with you have been incredibly responsive in answering questions. And so I will take you up on that further after this meeting for some of these questions. And I ask everyone else to please use Stephen. He's an excellent resource. And we have another meeting starting at 7:30. So I'm just going to stop this recording.
And yes, thank you for that. And yes, if anyone has questions, please feel free. I do try to respond. Some weeks are better than other weeks in according as soon as I can. I am in the process of catching up my emails now, but I do try to get to everyone, or at least acknowledge I receive their email and try to give them a timetable when I'll get back to them.
Okay, great. Jason, can you stop the recording, and then I will give everybody the link. The time sent to the panelists were switched, so just.
Yeah, because I believe my colleague Manuel is signed on
Okay, good.
as well.